Gentlemen, welcome and good afternoon. I thank you all. Please continue to enjoy your lunch. You are about to discover that the one reason I was asked to moderate this panel is that I sound a little bit like Lord Vader. Though, as you can all see, I look exactly like Denzel Washington. Except those of you who are truly visually challenged. My name's Bill Coons. I'm a district court judge in the Eastern District of New York, sitting in Brooklyn. I hope you'll all come and visit. And I want you to know that we're going to discuss today the joys and challenges of the use of disparate impact analysis, a theory of liability prohibiting an employer from using a facially neutral employment policy having an unjustified impact on members of a protected class as defined under Title VII of the Civil Rights Act of 1964. Our distinguished panel, you have their bios, Roger Clegg of the Center for Equal Opportunity, Yeomans of the American University, Washington College of Law, Professor Riva Siegel of Yale Law School, and the Honorable Kenneth Marcus of the Louis D. Brandeis Center for Human Rights. Stand ready, as we children of the 1960s would put it, to rock and roll. Now, the most cursory reviews of the bios, the respective bios, of our distinguished panelists and of your undistinguished moderator reveal the following. They know virtually everything there is to know about this topic, and I know virtually nothing about this topic, which assures you that I will consume little of our precious time today. However, since I'm an Article III judge and I do briefly have the podium, I do have a brief disparate impact story to share with you and with the panel, and I've not shared this with them on our call before we begin. I assure them they do not have to address it, and I pray that Justices Thomas and Scalia will overlook its foreign law origins. A number of years ago, to determine whether communism was really taking hold in the countryside, Moscow sent a number of bureaucrats to farms in the hinterland, armed with 3 questions for the farmers. So the bureaucrat approaches a farmer several hours outside of Moscow to begin the survey. Comrade farmer, we need you to answer 3 questions to determine if you are a true communist. All right, comrade bureaucrat, responds to the farmer. What's your first question? First, I asked, if you were asked to give your neighbor second shirt, would you do so? The farmer said, yes, of course. Good. Next, comrade farmer, would you give him your second pair of pants? The farmer said, yes, of course. Good. Finally, would you give your neighbor your second pair of boots? At that question, the farmer stood up, grabbed his shotgun from the wall, pumped in 2 shells, pointed the weapon at the bureaucrat, and stated calmly that the bureaucrat had 30 seconds to leave or the farmer would blow him in half. The stunned bureaucrat said, I do not understand you, comrade farmer. You said okay to the shirt. You said okay to the pants. Why not okay to the boots? Because, said the farmer with a smile, I actually have a second pair of boots. Now let us turn to our experts. Roger, disparate impact, bad policy, bad law, 10 minutes.
Okay, you ready? Are you going to yield the podium or?
If you like. You can either talk from there or at the podium.
Well, thank you very much for the introduction and to the Federalist Society for the opportunity to speak to you all today. 10 minutes is not a lot of time.
So
It's actually less than that now.
it is like that. So I will endeavor to talk quickly. The first thing to do, I think, is to define what a disparate impact cause of action is. And the judge is quite correct that a disparate impact charge does not require the challenged practice to be discriminatory in its terms, or in its intent, or in its application. If the use of a criteria has a disproportionate impact on the basis of race, and I'm going to be talking mostly about race today, but you can use it in any protected category you like, then that's enough to prove liability. And intent is not only something that doesn't have to be proved, but it's irrelevant. In other words, if you had a defendant who could prove that he adopted the challenge practice without discriminatory intent and that he was applying it evenly to all, that doesn't matter. It's not just that it's a way of showing intent, it's that it redefines definitions so that intent is no longer relevant. It is true that in a disparate impact lawsuit, the defendant can win, even though there is a disproportionate racial effect. But he has to show some degree of necessity for using the challenge practice. And even then, and typically the burden of proof is on him to make that demonstration. And even then, he can lose if the plaintiff then shows that, in the plaintiff's opinion, the defendant could achieve the same end using some tweaked procedure that had less discriminatory effect. Now, the problem with this approach to civil rights law is, first of all, that it makes it illegal to use a lot of practices that are perfectly legitimate. Not only non-discriminatory, but that serve perfectly valid and important ends. Moreover, the other inevitable result of this approach is that it encourages those covered by this area of the law to get their numbers right, to use surreptitious quotas or other preferences to ensure that these disparities don't happen. And Ken Marcus is going to talk some more about that consequence of this approach. The justifications for it, I think, are quite implausible. One claim that's frequently made, particularly in the popular press, is that, well, it's very hard to find a smoking gun these days. You know, defendants are much more cagey than they used to be, and they're not going to admit that they are doing things with discriminatory motive, and that makes it impossible to win these lawsuits unless we refashion them so that they can be brought under the disparate impact standard. But of course, you don't have to have a smoking gun in order to win. You can use statistical evidence and all the other kinds of evidence that's used in a disparate impact lawsuit. But what the disparate impact approach does is actually redefine the defense. It's as if the government were to say that, you know, we've decided that it's very hard to win these prosecutions for illegal drug smuggling. So we're going to say that you're guilty of illegal drug smuggling if you come into the country illegally, period. And it's no longer even relevant whether you have drugs. It's no longer even relevant if you can prove that you don't have drugs. The offense has been redefined, so that's something very different. The other defense that's sometimes used for the disparate impact approach is that, well, you know, all you have to do is just show that you have some good reason for it, and then the defendant can win. As I've noted, though, that typically the showing has to be one of some degree of actual necessity. even then you don't necessarily win. And you're having to convince a jury or a federal bureaucrat or a judge, and with all respect, the judge may know nothing of your company, may know nothing of what is necessary in your area of business in order to compete. And if you fail to convince him, then you've lost. And lawsuits are expensive as well, win or lose. I'm going to spend the balance of my time correcting one mistake that the judge made, implicitly at least. No, I don't think it was a deliberate mistake, but it had a disparate impact on accuracy. And that is that it is not limited to the employment context. It is true that it's become famous in the employment context, and the leading Supreme Court decision in this area, Griggs versus Duke Power Company, was an employment case. But it's actually an approach that has metastasized so that it's being used all over the place. Frequently in areas where there's no statutory justification for it. There is one statute that has always had a disparate impact provision in it, and that is Section 5 of the Voting Rights Act. As a result of that, the principle use to which Section 5 is now used is to encourage racial segregation and racial gerrymandering. This is typical of the kinds of bad effects that the disparate impact approach to law has. The Supreme Court, in its Griggs decision, found a disparate impact cause of action under Title VII, which was not there. But Congress has since amended the statute so that it actually is there. However, those are really the only two statutes where you can actually find disparate impact provisions in the statute, with the exception of the Americans with Disabilities Act, which is a different set of issues there. It is used by federal bureaucrats and by civil rights plaintiffs under the Fair Housing Act. The Supreme Court has never okayed that. The civil rights groups and the Justice Department are scared to death that the Supreme Court will resolve this issue someday, and so they're doing everything they can to keep it from getting to the Supreme Court. Because of its coverage because of its use under the Fair Housing Act and also the Equal Credit Opportunity Act, it's used in credit, in lending, and insurance. In addition, it's used for a variety of regulations promulgated under Title VI. Title VI is a statute that the Supreme Court has said requires disparate treatment for there to be a violation. Nonetheless, there are lots of federal regulations that use the disparate impact approach. So we find it being used for school discipline. In the Clinton administration, it was used to challenge SATs, the use of SAT scores. It's used to challenge practices that where somebody who receives federal money doesn't translate the services of the entity into languages other than English. And so the theory is that, well, this has a disparate impact on the basis of national origin. It's used to challenge police procedures that have a disproportionate racial effect. It's even used to challenge pollution. In other words, if you have a regulated entity that uses a pollutant in a way that hurts everybody without any racial disproportionality, that can be okay. But if it, for instance, if a plant is located in an area that is disproportionately this race or that race, then it's said to violate Title VI. It was even used in the Clinton administration to challenge the delivery of pizza under Title II. There was a pizza company that refused to make, or had a policy of not making door-to-door deliveries in high crime areas. It had only curbside service in high crime areas. And as a result of that, there was a disproportionate racial impact. And the Clinton administration sued the pizza company for having this policy, which of course was not motivated by race, but simply to keep its drivers from being mugged. I'm going to stop there and just say that I think that there are two important areas to address whereby this problem can be addressed. One is through litigation. I think a lot of the uses of disparate impact are on legally very shaky ground. For instance, all of these Title VI regs, I think, can be challenged as being ultra vires, since the statute itself doesn't allow for the disparate impact approach. And in addition, I think that this is an area where Congress should be asked to act. It should at least stop enacting laws that allow the disparate impact approach. It should spell out in new statutes that disparate impact approaches cannot be used. And it might also change the law so that a defendant can win a lawsuit if he can prove that the challenged action was not taken with discriminatory intent. Thank you very much.
Thank you. No one should have been surprised that a rule that would keep a pizza delivery man from Bill Clinton's door was Well, I believe, William, you perhaps have a slightly different view.
Shall I?
You shall.
Okay, well, first I want to thank the Federalist Society for inviting me. And I noticed that they sat Roger on my far right, and I'm on the far left, and I hope not to disappoint. Let me... I know. That's why I said mine.
But as always, Jerry, you're to our right.
Yeah,
So.
Okay. Listening to Roger's overview, it's hard not to sit there and think, my God, how is the Republic still standing since it's being governed by disparate impact rules? And I think that I take issue with his suggestion of the breadth of their application. But rather than go into that in detail, I guess the first point that I really want to make is that this debate is, in more general terms, one more about how vigorously we as a society want to enforce our anti-discrimination laws. And disparate impact and disparate treatment are points or maybe blobs on a continuum, and they overlap considerably. Whether the cause of action is disparate impact or the quest to find intentional discrimination, cases proceed in pretty much the same way. The first thing that people look at is the disparate impact. And as the Supreme Court has recognized, it's very persuasive evidence of discrimination, whether discriminatory intent or a disparate impact finding. And then those cases naturally proceed to a showing by the defendant of the reason for the practice that's being challenged. To some extent, standards can diverge at that point, but the approach is very similar. Let me just go back to basics for a minute, and Roger touched on these, but I think we have a somewhat different view. As I see the disparate impact theory can serve several different functions. So as it is a means of remedying intentional discrimination without having to do the societal harm of labeling someone an intentional discriminator, a racist. It recognizes that, as Roger suggested, intentional discriminators today are more subtle than they used to be. And it's not only the absence of smoking gun evidence, it's the fact that many of the practices that are challenged in civil rights actions are fairly complex, sophisticated transactions that may contain smoking guns, but There are players at numerous levels of decision-making, and it can be a complex analysis. Imagine, redevelopment actions or lending transactions, for instance. And I think disparate impact recognizes that the kind of evidence that's necessary to establish intent, whether it's smoking gun or strong circumstantial evidence, is going to be under the control of the defendant. So it's important to make the defendant come forward and produce a justification and to test that justification. I think it's also worth pointing out that disparate impact to some extent accounts for the subconscious and implicit bias that is in our society, both in us as individuals and in our institutions. There has been substantial psychological work in the last couple of decades that demonstrates, I think, quite educationally for all of us, that there is a good deal of subconscious bias in our daily decision-making. But beyond that, disparate impact theory does recognize that sometimes people act unthinkingly and that their actions can have disparate consequences based on race or gender. We're talking primarily about race. I'll follow that lead. And that it simply makes sense, if we're going to build a more inclusive society, to examine practices that do have that kind of impact and to make sure that they are justified by some legitimate purpose. And to ask the question whether they can't be served in ways that are less discriminatory, less exclusive. So I also think it's worth pointing out, and this whole discussion really doesn't make a lot of sense if you start at the end. So I think it's worth pointing out why disparate impact theory works in our society at all. And it works because of our history of discrimination, basically. Because of centuries of massive racial discrimination, centuries of slavery followed by a walloping dollop of Jim Crow, a large segment of our society has been left at a severe disadvantage. And we have done a good deal to address the effects of those years. We certainly have not yet done enough. If you're simply looking around at basic statistics, I think roughly a quarter of African Americans live below the poverty line. African American unemployment is roughly double that of whites. African American youth unemployment, which runs, I think, in the high 30%, is also double that of white youths. And of course, we have African Americans have far lower rates of home ownership and income and inherited wealth, all the measures of things that make for success in our society. So I suppose we can pretend that all these things don't have their roots in our centuries of intentional discrimination, and surely there have been intervening factors, but there is no other way to explain them. So what matters is fixing our problems, and I think it's a distraction to get hung up on the notion that what we really need to do is point fingers. The harm is measured by the effects on victims. When our foundational civil rights laws were being considered, we thought about making it a crime to engage in discrimination. And surely if we were going to punish people in that way, it would make sense to require a showing of intentional discrimination. But if what we're really about, and we rejected that, of course, and if what we're really about is solving problems, then disparate impact makes a lot of sense. And while I think you heard some of the litany of horror stories, I would just point out that there have been some enormous successes, and I would actually use one of the examples that Roger used, which involves police departments. And many of our major police departments were desegregated because of the use of disparate impact theory, because of challenges to hiring criteria and to written tests that disproportionately excluded minority applicants. And today, most of our major police departments look much more like the communities that they serve. And I have yet to talk to a chief of police who does not think that that's a very good thing. I think the big complaint of Roger and people who speak out against disparate impact theory is that it leads to a level of race consciousness. In other words, people have to think about race, they have to think about gender. I think one response to that is good. We should be thinking about race, we should be thinking about gender. If our goal is to build a more inclusive society. The argument that we can't think about race, of course, is familiar to all of you. It is driven by people who want to simply say, okay, we may have had a problem, we passed some laws, the civil rights era is over, it's time to move on, we've put all that behind us. I think nothing could be further from the truth. So, as I start off by saying, I mean, what this issue is really about, I think, is how serious we are about enforcing our anti-discrimination laws. And to a large extent, I think what we're seeing is a crusade to limit the scope and effectiveness of our civil rights laws. And there is not a majority in our political branches to do that at this point. So it's up to 5 members of the Supreme Court. Actually, I think 4 3/4 justices probably. And I would be remiss if I didn't touch on Section 5 of the Voting Rights Act, which Roger mentioned, which clearly was our most effective effects test ever. It was, Section 5, of course, is the provision that required covered jurisdictions to submit election changes for preclearance and to demonstrate that they were not, did not have the purpose or the effect of discriminating. As you know, the Supreme Court basically put preclearance on the shelf last term by striking down the coverage formula, Section 4 of the Act. This following reauthorization of the law in 2006 by Congress, by a unanimous Senate, with only 33 votes against in the House, based on a 15,000-page record that was compiled in the Congress. I feel a presence. There is a lot more to say. Let me just say that I hope we'll get to it, that of course the Fair Housing Act has been very much in play lately, even though there was a settlement, there is a settlement in the Mount Holly case in which the court had granted cert. The court is obviously very eager to get at the issue whether the Fair Housing Act contains an effects standard or not, and I hope we'll get a chance to discuss that. So in conclusion, let me just say that I think that it is important for us to get away from approaching disparate impact theory in a kind of a rigid ideological way and view it as the pragmatic approach to anti-discrimination that it is. Thank you.
Thank you, comrade. Thank you, Professor.
I accept the compliments.
As you know, we've had orders in New York which have, and in fact have increased the number of minority police officers, and we haven't had any problems with stop and frisk in New York, as you all know, in recent years. Reva, would you care to address some of the issues that these gentlemen have touched on? You can have as long as you like within the 10-minute frame.
Okay. So I think I'm going to be traversing ground that we've already covered, but as I understand the sequence of our comments, Ken and I are going to start nudging towards the constitutional direction. And so I want to start by rehearsing where we've been and then move forward, assuming our moderator lets me.
Talk fast.
I will. To get to the constitutional frame here, or to begin to open it, which I assume is going to take a longer conversation. I want to thank you for having me here, and I will enjoy the conversation that ensues. So we've talked about a couple different rationales for disparate impact law, and I want to disaggregate them. I think some are probably more contentious than others. The first that we've heard is that disparate impact laws are intended, well, the largest frame is we have societies that were organized for centuries, if you will, by race, by gender. They've committed to changing course. A disparate impact frame is a framework for probing how thoroughly the past is past and in what ways it continues into the present. One kind of discrimination that a disparate impact framework is probing for is hidden intentional discrimination. It may well be that it doesn't have to be proved in every case. The question is, how prevalent is it? That's a question about which we have very different assumptions in this society, and we don't have the proof. The whole point of it being hidden is we don't know what's transpired. So one purpose is that it is a method for both remedying and inhibiting intentional discrimination not disclosed to the public. A different one is that after centuries of race and gender-based differentiation, people understand the world in race and gender salient ways. There is implicit bias, to use the term here, and there is considerable social science evidence that these forms of reasoning persist, so that decision makers who are committed to equal opportunity, who understand themselves not to be reasoning in this way, may nonetheless be doing so. I just pulled like one example. Job applicants respond to newspaper ads submitting resumes. The same resumes get different responses depending on the names, with African American names taking 50% more applications to get a call back than resumes with white names on them. Other examples involve applicants for home loans that are filled out with the same financial data but different names. So this is just a way of testing that these forms of a bias are out there, they persist. Again, the depth in any given institution is debated. A third rationale is not about conscious, hidden, or unconscious bias in decision makers, but rather about the effects of that kind of bias over time, shaping differences on average among groups. And disparate impact frameworks are saying those differences, where they exist on average, shouldn't be made to matter in decision making, except insofar as it's functionally relevant to the purposes of the enterprise in question. And if it is, then it's a legitimate basis for decision making. Given my energetic moderator here, I'm going to very quickly move on to observe that even though there's a tendency dramatically to oppose disparate treatment and disparate impact theories of liability on the view that one promotes equality of opportunity and the other equality of result, in practice there's significant overlap in aims. There are important respects in which disparate impact regimes are probing for bias of a kind that, if remedied, will promote equal opportunity. There's a second rationale for the regime, and that is that it promotes public confidence in the fairness of decisions, where decision-making criteria exclude at dramatically disparate rates. Some may look at the results as being the outwork of natural differences in taste and talent across groups. Others may look at the results as, in fact, evidence of bias in the decision-making process. In a society of divided views about the salience and meaning of race, the exact meaning, legitimacy of the decision will be contested. But there's no doubt that for many, systematic exclusion from an institution through the use of facially neutral criteria will raise suspicions that bias is at work. We could go into any of these examples in greater detail. I just put it out there that this element of confidence, trust, and ultimately, and perhaps in this room it sounds counterintuitive, promotion of social cohesion is among the rationales for a disparate impact framework. So, having named these things, I want to point out that for decades, this framework has been assumed to be constitutional, that in the 1960s and 70s, in fact, many judges required inquiry into disparate impact as a way of enforcing equal protection. It was coextensive with the equal protection inquiry. I want to remind people that in the lead up to Washington against Davis, there were courts that, in the period before Title VII was extended to public employers, applied Griggs to public employers directly under the Equal Protection Clause. If you go back and you read Washington against Davis, you'll see the court says, it's a close case, but we beg to differ. In fact, I think it's something like 8 courts of appeal had already gone down that road, interpreting the Constitution in this direction. Davis holds that, in fact, as we know, the Equal Protection Clause showing a violation requires proof of purpose rather than impact. Impact is relevant to proof of purpose, but the ultimate constitutional fact to be proved is the question of purpose. But in holding this, the court observed that Congress was free to adopt impact rules as a matter of statute. The Constitution did not require it. In other words, that disparate impact Davis holds is permitted, not required, by the Equal Protection Clause. I want to actually read you the exact sentence that closes the opinion. This is Washington against Davis. In our view, extension of the disparate impact rule beyond those areas where it's already applicable by reason of statute, such as in the field of public employment, should await legislative prescription. So that's Washington against Davis. There are now emergent, and I'll further add that in the 80s, the debates over disparate impact by fierce critics of disparate impact were conducted on statutory grounds, not constitutional grounds. That is, there was a shared premise that this was permissible under the Constitution. So we are now in the Ricci world in which members of this panel, members of the court, are beginning to ask whether there is, to use Justice Scalia's terms, a war between equal protection and disparate impact. That is to say, they are engaged in changing the meaning of the Equal Protection Clause, in changing doctrine. And my closing questions here, which are really intended as an invitation to conversation, is really to inquire about the extent of the change that is contemplated. This has not been law. It is now contemplated as a possible new meaning of our constitutional law. And the question is exactly what is the scope of the change contemplated? Is the claim that these laws have bad purposes, have unconstitutional purposes? That's a question raised in Justice Scalia's opinion. If so, is this new claim of bad purpose calling into question all anti-discrimination laws or only disparate impact laws? How could that be, namely that it would only call disparate impact laws into question, given the overlapping concerns that shape disparate treatment and disparate impact laws? There's a lot of assumptions about social fact and about constitutional meaning we'd have to probe if we want to say that they're split apart, unless maybe these two claims are riding together and the Equal Protection Clause is now going to bar civil rights legislation in a more general sort of way. My second question, can these new claims about discriminatory purpose be reconciled with practices of narrow tailoring that the Supreme Court affirmed in its recent decision in Fisher? That is to say, with the pursuit of diversity by facially neutral means, something that garnered the vote of 7 members of the court and surely also Justice Ginsburg's as well, so let's say 8 members of the court. Can it be reconciled with the forms of race-conscious facially neutral state action affirmed by Justice Kennedy in Parents Involved, in his concurring opinion in Parents Involved? Or is the understanding of purpose in fact going to call for the reversal of these features of our constitutional doctrine as well? Finally, if the court is going to expand concepts of discriminatory purpose under Feeney to reach disparate impact, that is to say that Congress, in enacting a disparate impact regime, is engaging in a form of discriminatory purpose that is cognizable under Feeney, is this liberalization of proof going to be extended to minorities making claims about discriminatory purpose, or are we developing a separate rule for bringing majority and minority claims of discriminatory purpose under the Constitution? Not clear to me exactly where the sort of proponents of changing the law are headed. These are questions I'm putting on the table. My final question here is whether the Constitution is being interpreted to prohibit racial consciousness or racial discrimination. They're not the same thing. So what's the bottom line view of equal protection? Is the purpose of equal protection to protect all racial distributions or only some? Again, I'm not advancing an argument here. I'm asking about the direction, the directions of the arguments which are now emerging. Stop there.
Thank you. It's always a difficult thing for a Harvard person to ask a person from Yale to sit down and stop talking, but I'm going to manage to do that. Well, Ken, it's all up to you. You're on.
Thank you. I thought you were about to say there's nothing left to say, so sorry, time's up. But I'm glad you think there's a little bit of space. Thank you, Judge. Thank you all. I'm always flattered to be invited to a Federalist Society event here. We have a fabulous panel and also a distinguished audience. I recognize some friends and colleagues in the room, and I'm glad to see you. I had assumed that we would be obsessing today over Mount Holly and what the Supreme Court would say about that, and whether the court would say that HUD's disparate impact regulations were properly authorized by the statute or not. But it turns out that there were some civil rights advocates who were, according to rumor, scared to death that case would still be pending when this panel was held. And so they apparently scrambled to a last-minute settlement yesterday before it could be shredded, as I think it would have been within the first 10 minutes. So I always enjoy disparate impact cases. When I hear about disparate impact, I'm reminded about some of the cases that we got at the Office for Civil Rights at the Department of Education. And all of the very smart and interesting things that our recipients had to say about it. When we got a call from a school district, it was usually my sense that it represented what lots of other recipients were thinking and didn't stop to talk to us about, because in general, people do not call the federal government before they're about to do something stupid. And so if somebody does that, it's reflective of all of the other people who are doing something similar and not bothering to check with us in advance. So on one particular occasion, we got a call from a school district which had very thoughtfully considered their legal obligations. They had done a survey, and they determined that throughout their district there was a highly disproportionate number of African Americans who had been designated as mentally retarded. This was actually a concern of mine, and I had an initiative dealing with misidentification of minorities for special needs services, which I think is a significant problem. They saw that there was a significant number of African Americans who had been designated as mentally retarded, and they called to ask us how many white students they would need to designate as mentally retarded in order to comply with federal responsibilities. And I enjoyed the elegance of this because they were looking for either a specific number or at least some sort of arithmetic process for coming to this. Unfortunately, my staff corrected them before I could tell them to go ahead, and we need to do this with all of the other disparities that they have in the district as well. You know, I've got to say, when we criticize the use of disparate impact, as some of us do and some of us don't, to me, disparities are something we need to look at, not just because we're concerned in general about evenness in society, but sometimes it is, as at least a couple, if not all of our panelists have mentioned. Sometimes finding disparities is, at a minimum, a kind of smoke. My view is it's a kind of smoke that you look at to see if there's fire. Other people would say that it is the fire itself. I certainly spent untold hours looking through data of disparities in education to determine whether there were certain school districts that we should look at to see whether they had intentionally discriminatory practices. So I think that it is a legitimate targeting mechanism. But the question is how we use it legally if we find the disparities, and not so much whether we consider disparities to be important to look at to start with. I want to start by agreeing with at least one of my co-panelists, William, with his comment when he said that this debate or discussion is very much about the question of how serious we are about enforcement of anti-discrimination laws. And I think it is about how serious we are about that. And because I'm concerned about this, as I was getting ready for this talk, I decided to take a look at some of the cases that have been prosecuted very recently by the Obama administration, in the hope that they are more serious about it than some of us were prior to the Obama administration. And I looked at HUD's Office of Fair Housing because I was familiar with it, having led the agency a few years ago. And I decided what I would do is I would read the last several charges that they've issued, and I would keep reading until my blood boiled. Because, not anything, because HUD deals with real serious discrimination. I mean, we came across cases in which landlords would say, we don't want African Americans or black people or whatever word they use, we don't want them living here. I mean, there's real intentional discrimination, and you could agree or disagree about whether the federal government should deal with it, but I think we should all be angry with it and say that something needs to be done with it. And HUD has these cases. Other agencies deal more with cases that aren't really about intentional or conscious discrimination, but the Office of Fair Housing and Equal Opportunity, they get these cases. So I decided I would read them just to get angry and get sort of jazzed up for this. So I started looking at the most recent, and the first one I got was there's a disability case. That was the most recent charge, and I thought, good, I get angry about disability cases. We had cases usually with public housing providers, cases in which handicapped people were prevented from, they didn't have either ramps or they had stairs, and people would be falling off their wheelchairs and there would be no ramps built, and a really bad situation. So I looked at this case, and the first one, it actually involved a support animal. So it was a support animal, and I thought, okay, well, these are not the ones that really get me the angriest, but if you've got a blind person who is in your building and who says, I want to have a seeing eye dog, and you evict him because of that will get my blood boiling. I don't know about you, but that would get, it wasn't a blind person. So I thought, okay, well, a deaf person, sometimes they need a dog who will help them with street crossings or other. It was an emotional support case. My blood doesn't boil quite so much. Sometimes you get cases, I don't know if you're familiar with emotional support animal cases. Usually it's some woman has a dozen cats and can't live without them in an animal-free building. And they say no, right? Generally speaking, if it's one dog, they'll say okay, and it doesn't come to litigation. So this was an emotional support animal, and what I find is that when it's a sympathetic case, HUD will give you the details, and when they don't give you the details, it's a ferret. So I thought, okay, so I'm just not, so next case, okay. So the next case, it was a sex discrimination case, and I thought, these make me angry. Because you've got to understand, this is housing, right? So sex discrimination in housing is a little different with employment. Here you actually get cases, we would see cases where a woman could be raped in her apartment by a super. And that's, of course, it's rape, it's sexual violence, but it's also sex discrimination under Title VIII. There are sexual harassment cases in which women are told, okay, so you don't have the rent, here's what you can do for me, right? So I'm getting angry just thinking about what's going to be in this case involving it was a victim named George. Well, I was a little surprised about that, but apparently what George wanted to do in his mobile home community was to wear a dress. So it was a transgender case. Now, I don't know why he went to the mobile park owner to ask him if he could wear a dress. It was probably the first time anyone went to the owner of the mobile home park to ask about a dress code or something. But that's what George did, and George was told he couldn't wear a dress in this facility, and so HUD went after him. Now, The Fair Housing Act does not prohibit sexual orientation or transgender discrimination, but they went after him, and you could agree or disagree. I personally think they should have let George wear the dress, but my blood was not yet boiling on this one, so I went to the next one. And it's another disability case, and so I'm already getting agitated. And it was someone who gets SSDI, and they went to a bank and they wanted to take a loan, and the bank asked them for some evidence about the stability of their payments, how long have they been getting it, indication that they would continue to get payments over time. Okay, that's it. That's the case. That's it. And the problem here was that they were asking more questions than they would have asked if people were paying based on other sources of income. So, okay, I thought next one, I'm still not furious. So the next one was family of 4, very nice African, I think they were white people, but it was a family of 4, and they were kicked out of their apartment, or there was an effort to evict them, when mom got pregnant again. And it was a small place, I think a studio, and so the landlord said, there are too many of you. Now, again, I'm sorry, that's it, that's the case. Because, we did a survey when I was at HUD to find out, do most people know that it is unlawful under the Fair Housing Act to discriminate on the basis of familial status? And we found that most people have no idea, and they think it's a bad idea. But at any rate, that's the statute, and so this was the discrimination. The 5th case involved a person who called up and said, I went to this bank, and they, no, I'm sorry, it wasn't a bank. I went to a apartment building, and they didn't want to see me, and I think it was because I was black. Now, I initially thought there were lots of different reasons why someone might be turned down, having to do with creditworthiness, job stability, whatever. But they sent pair testers, black and white, to go, and it turned out that the place was available for the white, but not for the black. And then they sent another couple of pair testers who found again, black person shows up, sorry, it's unavailable. White person shows up, it is available. Finally, I'm getting angry. Okay? But I'm not just angry at this actual discrimination, the serious discrimination faced by the person who's going to get the apartment. I'm angry because I know that the Office of Fair Housing and Equal Opportunity has very limited funds available. It really is not able and has never been able to do a very effective job dealing with the actual intentional, conscious, or even unconscious discrimination faced by minorities. And yet, so many of these other cases are taking up their time, and I sometimes wonder, how effective would this organization really be if it could focus on cases in which people face discrimination because of their race, their color, their national origin, their sex, their disability, whatever it is. Oh my goodness, I barely started. So I agree, it is about...
Join the club.
It is about how seriously we want to enforce our anti-discrimination laws, but not in the way suggested. Let me quickly say, because it was guaranteed that I would say something about this, that there is this real tension between disparate impact and equal protection, and the conflict has something to do with this. Time and time again, institutions, whether it's universities, whether it's employers, have this challenge. They know that there will be disparities in what they do. There are always going to be disparities throughout our economy in every area. And yet they know that if they allow a disparity to persist, if they can't show a business necessity, if they can't show least intrusive, they are going to be on the hook. So what they often will do is find a way of eliminating the disparity. And how can you do that? Well, there are very sophisticated, resource-intensive ways to do this, or you could sort of fudge it. One way to fudge it is by using instruments that are designed in such a way that you will guarantee a particular outcome. So it forces employers and other institutions to ask the question, what is the distribution that we want of whites, of blacks, of Hispanics, what have you, and to use measures designed in that way. So for instance, in the Ricci case, and we're told that we live in a Ricci world, we read that the percentage of firefighters or police officers who could be promoted could have been different depending on the extent to which the written exam was weighed as opposed to the non-written. There are always going to be ways in which we can play with the numbers to get what we want to. But if our goal is to eliminate discrimination, which I think is what it should be, then this takes us down a different track and not necessarily the right one. It takes us down a track that might get us to what was called a more inclusive society, if that means a race-balanced one. But it gets us away from the notion of either a colorblind society or one in which people are able to advance based on their ability to do the job as opposed to their race, color, national origin. Thank you.
Thank you. We're now going to have a crossfire between the panelists, and then we will certainly allow time for questions from the audience, or Jerry Waltman has decided that he will take me out and shoot me because he never agrees to panel discussions without questions from the audience, and rightly so. I would just say, in terms of what is the ideal racial balance, I'm reminded of a story that was told to me many years ago about three bankers who work together, and they go out for lunch, and they're walking along a beach, and they kick a bottle, and the genie pops out of the bottle. And the genie sees the three gentlemen, and he says, well, look, guys, ordinarily you get 3 wishes, but there are 3 of you, you get 1 wish each. So he turns to the first guy, who's African American, he says, what do you want? He says, you know, I hate to say it, some of my best friends are Jewish, but I really wish every Jew were back in Israel. Genie says, okay, tomorrow at noon you have it. Turns to the other guy, he's Jewish. He says, what about you? He says, you know, I hate to be racist, but I kind of wish all blacks were back in Africa. Genie shakes his head and says, okay, you've got it. Turns to the third guy, old school, white Anglo-Saxon Protestant. Says, you have a wish? He says, I do. He says, but first, I want to know, did you grant the black guy's wish? I did. Did you grant the Jewish guy's wish? I did. He says, Diet Coke, no ice. Okay. Let's have some crossfire.
I can make a couple of comments on what was said, if it makes sense for me to start.
Please do.
I think actually that both the folks on the other side of the podium made three points that were quite similar, and I would respond to them this way. If it's the case that you really believe that the reason we have disparate impact causes of action is to get at intentional racial discrimination that cannot otherwise be gotten at, then I would think that you would have no objection to amending Title VII and the Voting Rights Act so that if a defendant can prove as an affirmative defense that he or she adopted the challenged practice or procedure for non-discriminatory reasons, they can prove that, then the case should be dismissed. Okay, so that's my first point. Second point, with respect to implicit bias and callbacks, the first point I would make about them is that is disparate treatment. That is not disparate impact and can be attacked as such. I think that there are junk science problems with some of these studies, but in any event, this is not really about disparate impact. Those are examples of disparate treatment. And then finally, with respect to racial disparities, let me read you a paragraph that was in an op-ed that I wrote in the Wall Street Journal. If a business agency or school has standards for hiring, promoting, admissions, or offering a mortgage that aren't being met by individuals in some racial and ethnic groups, there are 3 things that can be done. First, the standards can be relaxed for those groups. That is what racial preferences do. Second, the government can attack the standards themselves. That is what the disparate impact approach to enforcement does. Third, one can examine why a disproportionate number of individuals in some groups aren't meeting the standards. such as failing public schools or being born out of wedlock, and do something about it. This last option holds little interest on the political left.
Comments, responses?
I'll start.
Okay.
Either way. Let me start with the third. I think it's quite obvious that everybody across the political spectrum has an interest in trying to examine why the standards are not being met and trying to do something about it. And I think that most of us, certainly on this side, would support putting a great deal more resources into trying to deal with some of those problems. Now, I assume that we would have some differences over solutions, but certainly it is not for want of wanting to do something. Let me just talk about this notion of sacrificing merit. I think one of the things, and I think this point gets horribly overplayed, one of the things that disparate impact litigation has shown through the years is that the concept of merit can be refined, and that often when employers or others think that they are acting entirely on the basis of merit, they're not. And they are not using necessarily the most effective means of predicting performance on a job or performance in an educational setting. And to the extent that disparate impact makes people examine their conceptions of merit, I think it's an enormously healthy thing, and again, it can become a much more inclusive thing. Riva?
Let's see, quickly. So I will start with the suggestion that the differences that the social science data all concerns examples of disparate treatment. And I want to invite people to ask what it is we mean by disparate treatment. Are we converging a statutory concept of disparate treatment with the idea of intentional purposive animus? Or are we saying that two people with equal qualifications are being treated disparately, whether or not the decision maker is aware of his or her bias? And I think, Roger, when you're saying disparate treatment there, you mean it's all intentional.
No. I mean, I think that if you have...
So this seems productive to say, what are you meaning by disparate treatment?
I mean, well, disparate treatment means somebody is being treated differently because of their race.
Meaning because of the agent
and-
is aware that he or she is making the difference?
Because, let me give you an example, okay? I may have an unconscious bias against women or against African Americans. And as a result of that unconscious bias, I treat those individuals worse. That is disparate treatment. Disparate impact is, as I said at the outset, when people are not being treated differently because of their race. They're being treated differently because of something else, some other criterion, some criterion which is neutral on its face, neutrally intended, and neutrally applied. But it has a disproportionate racial effect. That is what disparate impact is. And that is the, I don't think that that's racial discrimination. That is not treating people differently because of race.
Ken,
So-
why don't you pop in and then we'll go back.
So I'll just say, in response to William's comment, that yes, there are times when discrimination is hard to prove. It may be conscious, it might be unconscious. And I agree that there are times when a burden-shifting device can be helpful to smoke out discrimination that is hard to identify or to prove through other means. The problem arises when there isn't either a good faith defense or a defense which can be raised in such a way as to screen out those disparities that arise from discrimination and those that do not. So for me, one of the answers to Riva's question is that the problem is not with civil rights or anti-discrimination statutes per se, nor is it even with burden-shifting tests to find discrimination. The problem arises when race-conscious methods are chosen, especially ones that have an effect that's close to a quota, and they are not motivated by an intent to eliminate discrimination, but rather to eliminate disparities that could arise from other reasons.
So I guess this helps clarify. I think that there is a dramatic difference of opinion about both the availability of tools to prove whether decisions are the result of bias, conscious and unconscious. I mean, that point seems to me very deep here. To the extent that there's concern about where the burdens of proof are falling, that's de facto agreement that something's at stake in the proof issue. There's also disagreement about the prevalence of bias, especially the prevalence of bias that's unconscious as well as conscious. And if, in fact, it's not easy to prove, and in fact, part of the bias is bias of a kind that decision makers are themselves not wholly aware of, there's even less likely there's going to be proof available of subjective decision making. We're talking about a problem that's unrectified and will shape the ways in which norms are enforced and even adopted. And this framework is a framework which has the power to invite administrators and institutions to probe the standards they have to make sure the standards are actually serving the functional ends of the enterprise. There is supposed to be a test here, whether you call it business necessity or however you characterize it, that says essentially if you can show the reason that you're using a particular criterion in terms that are integral to your enterprise, then whatever impact there is lawful, not unlawful. So this probing exercise is undertaken with concern about there being persistent, difficult to prove bias still out there in a society that only relatively recently has shifted course. And it becomes, in essence, I think, a political decision whether a community thinks the problem is pervasive enough that it's worth adopting a framework that will probe when these disparities exist to determine whether, in fact, they're functionally justified or not. And I guess I'm just, can I just say that I think it's important to identify, just to disaggregate, Roger, that's all I want to say, is to disaggregate the political question from the constitutional question, which we haven't been able to get so far into, with the notion that, indeed, I hear part of what's being said here is that elected officials may have different views about the extent of the problem, the prevalence, and they may want to change the laws or change the way the laws are enforced. I see that as a different question than the question we might give to federal judges about what they're going to strike down. I just wanted to separate those two.
Well, you may respond.
Judge, I was going to compliment you on your prescience in using, in opening this session with a joke from the Soviet Union. I think that, with all respect, there is another fundamental cleavage between the two sides of the table, and that is the extent to which in the United States, decisions about whether or not something serves the functional interests of the organization are to be left to the organization, the private organization, and to what extent it ought to be probed by a lot of federal bureaucrats and judges. And I think that the amount of that probing should be quite limited, that there should be an enormous presumption that private entities ought to be making those decisions for themselves, and that it's a bad idea to ask judges and bureaucrats to do, to be second guessing what are essentially, business decisions. It's much more reasonable to say that judges and juries and bureaucrats can look at specific questions where there's a strong historical predicate, like, is somebody being treated differently because of their skin color? I'm okay with that. But I'm not okay with, having HUD decide whether the interests of the landlord in this tenement are being functionally, served well, or whether there's something that, the HUD bureaucrat in his or her wisdom thinks would really be just as good in terms of serving the functional interests of the tenement.
Let me ask the entire panel, does it matter that it's the HUD bureaucrat as opposed to the Director of Housing for the state of New York as opposed to City Hall? Is it a question of federalism and the national government doing it through its regulators as opposed to state regulators or local municipal regulators? Does it matter? Maybe
Well,
it doesn't.
I think they're bad. I think that getting any government involved is a bad idea. They may be bad for different reasons. I think, Federalist Society, I think Federalist 10 points out that in some respects, actually, having local regulators making these decisions may be worse and more corrupting in some instances. Although, as a conservative, I do have some greater instinctive distrust of Washington bureaucrats rather than local bureaucrats.
What's your view?
I think it depends very much on, the quality of whoever is doing it. And certainly as someone who's spent most of his career at the Department of Justice, when it comes to talking about the quality of decision-making at HUD or the Department of Justice, I tend to think that there is a difference. But I think it's all too easy to go through anecdotes that suggest the incompetence of government officials. There obviously will be examples, but it is, I think, a serious mistake to base a serious policy discussion on a few anecdotes. And I'm not here, I don't have the information to defend the entire HUD bureaucracy, but I'm sure that the HUD bureaucracy deals with some very serious complaints. And in response to Ken's point, I think the answer to the problem that he quite aptly described at HUD is to strengthen that enforcement office. It is not to say that it has to stop looking at a variety of kinds of discrimination. It is to give the office the resources that it needs.
You've talked about employment, you've talked about housing to some extent. What about the question of education?
Could I quickly respond to that and then?
Yes.
Okay. I actually did not intend to disparage the staff at HUD, nor even their senior officials. The current acting assistant secretary is a career official who worked for me at one point, very smart, very good. The immediate past assistant secretary also worked for me at one point, very good. The problem isn't that they were acting erratically. All of these cases are the sorts of cases that naturally come out of the system. If you are a very smart, competent bureaucrat at HUD following the regulations and the laws scrupulously, these are the kinds of cases that come out based on the system that they have. So I agree that any of these agencies can be strengthened. But even if you increase the budget by 10 times, you wouldn't have enough resources to deal with all of the actual discrimination if you are handling all of the other cases that I think are questionable at best. Education brings up, I mean, a multitude of issues, and I know that this administration has been outspoken about wanting to use disparate impact much more frequently. So we have investigations as to whether discipline is used in a disparate way by race. We see cases in which high-stakes tests are challenged based on the results. My view is that these are not bad questions to ask. If I saw in a particular district that there were a large number of minorities who were being punished and a small number of whites who were, then I think that is the good beginning of a question about why that is. But the problem that I would be looking for is not, well, here's a disparity, how do we level it? For me, the question is, here is a disparity, what is the cause? And my concern is that under disparate impact, it's not just that harm is measured by the effects on victims, as one of the panelists indicated. My concern is that too often under disparate impact, discrimination is defined by the impact without looking to see whether people are really being treated differently because of their race or ethnicity as opposed to other factors entirely.
Let's have a response, and then we will open it up
I just
for
wanted to
questions.
say, that's a beautiful example of the ways in which concern about disparate treatment and disparate impact as a practical matter are overlapping. You know, when you're looking at institutions involving vast numbers of transactions in a lot of, in a lot of settings, numbers are going to start a conversation in which you ask, what's behind this? What's happening? If, in fact, particular administrators are responding to a disparate impact framework by just either leveling down or leveling up in a mindless way, that's bad administration. Nobody is trying to suggest that laws are always well enforced or well administered. There are better or worse versions of it. The question is whether there's something fundamentally suspect or different in kind about making this inquiry. And what we're suggesting is that there need not be. There's significant and dramatic amounts of overlap.
And speaking of significant and dramatic, we're now going to turn to Jerry Waltman with the first question.
Thank you, Judge. Gerald Waltman of the Board of Visitors here. I believe that many issues can be seen much more clearly by taking a simple example and a personal example, and one we are all seeing right now. I think we can agree that the Federalist Society did very well in picking this five-person panel based on ability to express their views. Yet, if you look at the percentages, there's this disparate prejudice and discrimination against women, because there's only one woman out of 5, and we know that women have about 52% of the population, and yet there's only 20% here. Now, based upon that fact, of course, this is in a simple setting, a small setting, but frankly, I've looked at the list of participants in all the panels up to this hour, and the percentage is not much different. Why should the Federalist Society, and I think we all who have seen all the panels, can agree that the basis was not discrimination against women, but just picking those people who had expertise in that area and could speak well? Why should the Federalist Society, under the disparate discrimination statutes, face a lawsuit and yes, have to show, as will easily be shown, that everybody was chosen on the basis of ability? Why should the Federalist Society have to be put to the burden of defending such a case? This is an apocryphal, but it is what happens, and face the real problem of the settlement that often comes because of the expense and burden of the lawsuit. Why shouldn't we just follow the general rule that a plaintiff who claims wrong should have the burden from the beginning of pleading and establishing the wrong?
Anyone?
I think it's an excellent question, but I will question your premise. As it turns out, I can now reveal that everyone on this panel is cross-dressing. So, the disproportion is actually in the other direction.
Can I?
Go right ahead.
I'd just like to, I mean, thank you for your comment, but I'd like to ask you, do you think that the Federalist Society should be conscious of the composition of its panels in terms of race and gender?
No, well, I happen to think with Martin Luther King that the correct way of looking at the Constitution and race and gender is based not upon the whether somebody wears pants or skirts. Maybe that's not good today. And not on the basis of color, but on the basis of picking people who have ability and expertise in the field, and the judge has shown that that's what the Federal Society did.
So you don't think that, for instance, in a discussion of something as racially charged as an effects test, that it could make a difference to have people on the panel who had experienced that kind of discrimination or had some background that would bring a different perspective?
I think that people should be chosen on the basis of their understanding, their background, their ability, not background in the sense of color or gender, but background of what they've worked in, where they've had the experience.
But I guess my question is, don't you think that a background of someone who brings a minority experience or the experience of a woman or a man to this panel brings something different, particularly in a discussion of discrimination?
Well, I think it's sad that someone who is a liberal, and I consider myself a liberal in the old sense.
Me too.
Good. That should consider whether somebody is black or white, woman or male. When I was doing hiring for my law firm, I certainly didn't care for what sex or race, and we hired people based on who we thought would show the ability.
Here. I mean, I agree with that. I agree with your question and your point of view. And you know what, Bill, what you're suggesting is that we ought to stereotype, you know, in choosing people. We ought to assume something about somebody's background because of their race or because of their gender. I mean, it is really turning on, the whole disparate impact approach really turns on its head, you know, what Martin Luther King said. We are judging people precisely because of skin color, and we are forbidding people to make decisions based on the content of their character. I mean, look at the EEOC now using the disparate impact approach to say that employers can't consider criminal background checks because of its racial disproportion. That is exactly what Martin Luther King said shouldn't be done.
We will take the next question, and I will have to admit that indeed I was a chorus girl in a hasty pudding show. Cross-dressing before it was popular. Okay, go ahead.
Learning a lot from the panelists today.
My kids would call that TMI. Way TMI. Don't worry, the negatives have long since been destroyed, which is why I'm disappointed. They looked, but they couldn't find them. Go ahead.
Todd Graziano. And I was kind of intrigued with the way Bill Yeomans sort of tried to set the table, and it's a familiar one to me, in that the current disparities have to be because of the legacy of slavery or discrimination, because none of us, and I do submit, I hope none of us in this room believe in any genetic inferiority, and if there was one, I wouldn't know which way it ran. But here's the question that I'd like to pose to all the panelists. What if the evidence shows, by the way, I'd be very concerned with disparate impact under a constitutional standard, even if that were true, even if what Bill Yeoman said is true. But I want to just talk about the practical effect. What if the evidence, as Thomas Sowell has argued, I think, and others very convincingly, that the current disparities have more to do with caustic philosophies of victimhood, other sorts of social and cultural pathologies, then what would the argument for disproportion? And more importantly, what if Professor Amy Wax at University of Pennsylvania and others like her are right as a practical matter that regardless of the cause, that the disparate impact and those kind of remedies are disastrous and crippling to minority communities, and that they would permanently disable, that they're a part of a philosophy and part of a remedy that cripples minorities. Would you, those who support disparate impact, still support it if that empirical evidence were true? Or is, as I sometimes think with President Obama, that the result matters more? The result matters more that, than the helping the
We have your
intended
question, panelists. Who wants to jump in?
Well, I guess I'll start with the Sowell point. It's a fascinating feature of arguments for colorblindness that they could be premised on views about racial group differences and or sex differences. And I think it's good to drive that set of assumptions up to the surface. When they're there, my question becomes, how do you want to engage politically over that question? And do you want to suggest that federal judges interpret the United States Constitution based on the view that there are, in fact, group differences that the Constitution is protecting? I think that's a pretty long stretch, and I'm not sure it's
I
a
would
place.
not, and that's why I'm putting the Constitution.
I'm suggesting to you that it's the question that's on the table now. The briefs in the Mount Holly case were full of constitutional avoidance arguments. Ricci has got constitutional avoidance arguments. I've found it fascinating that there's not been a square engagement over the two questions, namely, what's a reasonable framework for our anti-discrimination law as a matter of political choice for the nation to face down, and what is the understanding of the Equal Protection Clause that federal judges ought to be enforcing no matter what it is the United States Congress decides. I think those are two very importantly different questions, and I think it's really important to run this conversation with attention to the difference between them. So then I would say we turn to national storytelling about the extent to which these differences are just about differences in character and taste, or whether there are other dynamics contributing to them, about which we could have a group speak out in this room and in other rooms across the nation. And I think it's an important conversation for us to be in. I welcome it. I wouldn't, however, try to enforce the Constitution based on a conclusion that's not widely shared right now, and certainly one that couldn't be arrived at stably through our politics. So,
Other panel members.
I think that the Supreme Court was right to interpret the Constitution as prohibiting disparate treatment and not disparate impact. And I think that a statute that encourages disparate treatment raises real constitutional problems.
Do you
and I
include
think
disparate
that the disparate
treatment?
No, Counsel, you'll have your opportunity.
And I think that a statute that penalizes people for not getting their racial numbers right, which is what a disparate impact statute does, is encouraging disparate treatment, and therefore does raise serious constitutional problems. And let me just to sort of flesh out.
Before you get there,
Yeah.
your response.
I had asked earlier whether your arguments extended to disparate treatment statutes as well. I think that when you're...
How does a disparate treatment...
Counsel? Really? Marshals? I'm sorry, I just can't quit.
If an employer, just to be very practical about this, if an employer looks out at a workforce and sees that it's dramatically stratified, someone who's in charge of a large organization doesn't know what the sources of those differences might be. They may just try to repair the problem using quota hiring without ever knowing what the root of it is. That could be an employer who's dealing with a statute that prohibits disparate treatment as well as disparate impact. I don't see that the incentives argument really is all that different in either case. And the incentives argument might be a policy reason for adjusting your enforcement criteria or for even altering the statute's reach, but for saying if that possible response is the basis that the Constitution, for a constitutional claim, I think it would actually reach almost all anti-discrimination laws.
You can reply after we get the next question from the next questioner.
Linwood Bragan, Capstan Counsel. Risking being tarred and feathered with this question. Regarding inclusivity and expansion of the standard, might we find some kind of an emanation from a number that's out there from public or government support for, say, the media, broadcasting, and entertainment industries, which comes in and lobbies rather hard for specialized tax treatments and incentives? They've been doing that since Valenti out of the Great Society, Congressman Dan Glickman, and now Senator Chris, Disparate Loan Impact, Dodd, coming in there. Looking at the impact that things are having, such as that treatment in Hollywood, would you favor expanding the disparate impact standard to include an expansion of the classes represented there, such minorities as Charlton Heston's off-cited Pentecostal, Bible-believing, evangelical Christian seeking to escape de facto blacklisting and employment numbers that are there?
All right, for the panel, who wants to jump in?
You know, I think as the law is written, it's already susceptible to that kind of interpretation. I mean, you know, there's, and, you know, I don't think that the solution to bad liberal disparate impact lawsuits is bad right-wing disparate impact lawsuits. I mean, I think, you know, here again, I don't know why Hollywood does what it does, but if there's discrimination against Christians in what they do, then I think that the way to get at it is to bring a Title VII lawsuit, which prohibits discrimination on the basis of religion, and prove that, but not to use, you know, the disparate impact approach. I don't understand how a disparate treatment statute could be fairly interpreted as violating the ban on disparate treatment in the Constitution. I think you're, with all respect, Professor, you're overthinking it if you see that problem. And then the numbers that I was going to give to sort of flesh out the cultural problems that that are the basis for the current disparities that we're seeing, whether it's in education or employment or crime or whatever, are these. More than 7 out of 10 African Americans now are born out of wedlock. More than 6 out of 10 Native Americans are born out of wedlock. More than 5 out of 10 Latinos are born out of wedlock. Versus fewer than 3 out of 10 non-Hispanic whites and fewer than 2 out of 10 Asians. Those are dramatic disparities, and they line up very well with the problems that the left wants to address through litigation, as opposed to asking what can we do to stop so many children from being born out of wedlock, whatever their color is.
Response and then next question.
Professor Yeomans, would you care to respond? My question?
Doesn't have to. All right, next question.
Hi, Chris Hand. Today we've been really operating at the 50,000 foot level, and I want to bring it down and really kind of hopefully bring some clarification, at least maybe even just for me. We have two overarching issues here: whether or not disparate impact should even exist, be legal, be used, and whether it should be used in cases outside of its traditional use, which is in employment. So I want to focus on the employment and bring it down to a very precise situation, a very classic case. An employer has an examination. They administer to 200, 500 applicants, and it has a disparate impact on African Americans. That is to say that African Americans fail at a rate higher than whites, and they fail at a statistically significant rate, which means that we believe that there's a likelihood that it's not because of chance, but there's some issue there. The employer, before even being contacted by the Department of Justice or the EEOC, says, look, this had a disparate impact. I'm not happy with this test. So they go to a contractor. They spend a lot of money, but they get what's called a valid test. A valid test is something that properly...
I know there's a question lurking.
What I'm trying to say is...
I wanted to strike.
I'm sorry. We haven't had... All right, I'm gonna assume my panelists will know what I'm talking about.
I know, but see, I don't, and I'm the moderator, so you really...
That's
the problem with trying these cases in district court.
All right. Ken and Roger, specifically, do you oppose banning a test that has a disparate impact and has not been validated under the federal guidelines?
Thank you for the question. Responses?
No, I mean, I think that what you should have to, if you don't, someone doesn't like that test, whether it's, you know, a government bureaucrat or a private party, they should have to come into court and show that it was adopted with discriminatory intent or is being applied with discriminatory intent or that discriminates on its face. But I think, you know, the validation process is often expensive and difficult. Again, these are decisions that ought to be left to the private sector unless there is evidence that people are being treated differently because of race. And if you can't show that the test was designed to hurt African Americans or that it was being implemented in that way or that it's discriminatory on its face, then I don't think that the federal government should be coming in there and second-guessing the employer's decision, you know, to use it. Employers go bankrupt if they have procedures that result in them not hiring the best qualified people. You know, capitalism has built-in disincentives for employers making stupid decisions.
Except for banks, which are too big. All right, comments over here, and then we'll take the next question.
Yeah, I mean, I would just say that a validated test is necessarily going to ensure that employees are hired who have passed the test, which is valid because it's a good predictor of performance in the job. So that certainly is not going to harm the search for merit, or should not harm the search for merit. I think whether or not the employer set out initially to design a test that was discriminatory or not is not the appropriate inquiry. If the test does have that disparate impact, and if it's not a valid predictor of performance, then I do think it should not stand.
Two more questions from these questioners.
Thank you very much.
Absolutely.
You're having too much fun today, Your Honor.
I am indeed. On a roll.
Jim Wass from Riverdale, Maryland. That's inside the D.C. Beltway. A 61-year-old first year, part-time. And so I come from other traditions, and in one of them I'm a race walk official, and I can look at somebody's head bobbing or see funny motion in the shoulders, and I will know for a fact that this person probably has a bent knee or is losing contact with the ground, both in violation of the rules. But I have to see a bent knee or see loss of contact with the ground in other words, the competitor does not have to provide an affirmative defense. I have to find the violation. So they have their protections in my other world. I don't hear the protections for defendant when you see disparate impact other than the defendant going through the expense and trouble of an affirmative defense. What protections do you see as existing right now for defendant, or which would you advocate to add to the mix right now to give me that confidence?
We have the question. Would you care to respond?
So there's, when I started my remarks initially, I made a simple point that I'd like to reiterate right now, which is that this conversation depends dramatically on where you start it running, what your presumptions are about the baseline transactions in the United States in workplaces around the country. Either you assume that bias, which once was the public order of things, has basically disappeared, or you assume that in hidden and in unconscious ways it persists. And a big part of the conversation here is a profound difference of agreement about the persistence of bias and about the social significance to attach to its eradication. So you can start by worrying about the burdened employer, or you can start with another set of examples about exclusions that happen on an ordinary basis that social scientists and people in their ordinary lives report, and depends on which one you're worrying about here. And one of the reasons we have a political process is so that we can talk to one another about the real problems that are out there, and that will shape the ways in which our laws are designed and enforced. And I'll observe that, in fact, in terms of yields in these cases, there's been a dramatic shift in the number of cases that plaintiffs have won over the last 30, 40 years, in part because there were arguments about the intensity of the law and the reach and the burden. And the question is, what's the right equilibrium point? One view is the laws should be wiped off the book and there'll be no remaining problem. And another view is you're telling yourself a story about a world that doesn't exist. There will be a remaining problem, it just won't be remedied, and there'll be no way of proving it. And that's where you and I are disagreeing.
Final questions.
May I just-
Okay.
Final questions, and then we will
Okay.
have observations from each of the panelists. Go ahead.
I had what I thought was a brilliant question about the notion that disparate impact is in fact ubiquitous. Everything has a disparate impact. For example, men on average are going to be stronger than women. Women on average are going to be able to do fine handiwork in ways that men usually can't do. Did you know, for example, that Cambodian Americans have cornered the donut industry in California, such that if you're looking for somebody with experience in the donut industry, the odds are this is going to have a very, very profound disparate impact. I have my checkbook with me, and I'm very happy to write a check for $10,000 to any panelist who can come up with a job qualification that has actually excluded or brought in a significant number of employees that does not have a disparate impact on some protected group. Remember, there are lots of them. There are lots of ethnicities in this country and lots of religions as well. That does not have a
We
disparate
have the
impact.
question, and we're going to start here and answer the question and make final comments, and we will go around, and then I will thank our panelists. You first.
If I say breathing, do I get $10,000?
Hasn't actually separated employees.
I just have some, some random points to make. I want to make clear that unconscious discrimination, while I think it does exist, is rare. Number two, when we're talking about school discipline disparities, I want to make the point that if the federal government discourages school systems from being aggressive in disciplining unruly behavior because of the disparate racial impact that will have, the people who will be hurt the most will be the children in classrooms that now have a lot of unruly students in them. And those students will be disproportionately African American. I think it's worth noting that the Employment Non-Discrimination Act, which would add sexual orientation to Title VII, which I'm opposed to, has in it explicitly that you can't bring disparate impact causes of action under it, which I think shows that even the left understands that this is not really discrimination that we're talking about. And then finally, a completely unrelated topic, but I promised Commissioner Harriet that I would make this point, and that is that any employer out there, including any university employer, that thinks that the Supreme Court's recognition of a diversity defense to discrimination in the school admissions context can be applied to the employment context is wrong. The statutes are different, and there is no diversity defense to employment discrimination. Thank you.
Ken?
Well, I'm surprised, Commissioner, you have the temerity to stand here as the chair of this practice group after applying facially neutral speaker selection policies that have had such a stark, disparate impact, but I'm glad to see you anyhow. I actually disagree with Riva about whether we can disagree about bias, because I actually happen to believe that there is a great deal of bias in this country, and that it is a serious problem that needs to be addressed more vigorously than we do under either Democratic or Republican administrations. My problem, though, is when in a particular case where we don't know whether there's any bias, we have a balance on the one hand between a disparity that could possibly, conceivably, be based on discrimination, although we have no real evidence that it is. And on the other hand, the way to deal with it is to adopt a system that has the certainty of involving discrimination, if, for instance, we throw out test results because of the people who came through, and perhaps also the certainty of having other kinds of adverse social results, for instance, when retailers or lending institutions are prohibited from doing criminal background checks. So in some cases there will be disagreement about bias, but in other cases we will think, yes, bias is both serious and widespread, but that means that we need to use our civil rights enforcement scarce resources more effectively and selectively, and that we should not tilt the balance away from remote possibilities of discrimination and in favor of a certainty of discrimination.
I know that actually you and I share overlapping concerns about persisting bias. I do think, though, that in this debate nationwide, that there are differences about what I would call racial common sense. In other words, the extent to which when people see stratification out there, the extent to which they explain it in terms of persisting patterns of bias as distinct from underlying differences either of culture or capacity. And in fact, we simply disagree about the way we interpret the social organization of this society, and partly we're arguing over that. Partly we're arguing over a separate question, which I want to connect with you over now, which is whether probing disparate impact is itself, and engaging in the forms of consciousness, group consciousness, that disparate impact inquiries represent, whether it is itself discrimination or whether it's concern about the sources of bias. I take it to be the latter, not per se discrimination. I point out that in the Ricci case, which was the firefighters' case of a few years ago, the test at issue shut out nearly all minority applicants from promotion over a long period of time. It wasn't a question of proportional representation. It was a question of something that in a different case O'Connor once referred to as the inexorable zero. And there is a point on this side's view of asking the question twice and in a way that isn't pointing the finger and accusing someone of intentional racism. In a fire department which has been fighting over the issue of racial integration for 30 years, and in a setting in which the standards were actually built into the employment contract by agreement between the union and the city for something like 20 years, tells the Ricci and the Briscoe case tells us. That is to say, there's a connection between the old world of intentional discrimination and the world we're in now, where we're not so clear what's happening and why. And I understand this framework as a tool for probing and making sure that we have it right, a tool for transitional justice in moving from one world to another, not an instrument per se itself of discrimination. I'm clear we're better off now than we were 40 years ago, but I'm not clear that we're in a world that has nothing to do with that world.
William.
Okay, I can't imagine that there is anything left for me to say, except to say thank you and congratulations on staying to the bitter end. And I hope you enjoy the rest of the conference.
Well, I will echo that and leave you with the following test that I was given many years ago, and I want to thank our panelists. Hat is to head as cup is to A, bare earth, B, bare floor, C, bare tabletop, D, saucer, E, all of the above, and F, none of the above. Think about the question, think about the answer, but tell your kids if they want to go to Harvard or Yale, the answer is saucer. Thank you. Thank our panel.